All right, good morning or good afternoon, everybody. Welcome to the November Colera meeting. We are here today for our National Labor Relations Board updates, and our speaker is going to be, and hopefully I'll pronounce this correctly, Naima Clark. Today, she is here because back over the summer on July 22nd, Jennifer Abruzzo began serving as General Counsel for the National Labor Relations Boards. And she is going to be speaking for us, Naima is, in reference to the initiatives that Ms. Abruzzo has implemented that will be impacting Ohio's workers and employers. She will be talking about initiatives regarding priorities such as the August 12th, 2021 mandatory submission to advice memorandum. And this talked about cases involving employer handbook rules, confidentiality provisions and separation agreements, defining the scope of protected concerted activity and Weingarten rights, along with the new prosecutorial position that certain players at academic institutions, sometimes referred to as student athletes, are employees under the National Labor Relations Act, along with information regarding how they are afforded statutory protections. Also expanding the variety of make-whole remedies that may be sought to ensure that charging parties are victims of unfair labor practices under the Act, how they receive complete relief, along with the September 2nd, 2021 letter of arrangement between the General Counsel's office and the Mexican Embassy regarding the joint intention to improve employer and worker awareness of rights and obligations under the Act applicable to all Mexican nationals who work or own a business in the U.S. Ms. Clark is actually a supervisory attorney in Region 9 here in Cincinnati, Ohio, of the National Labor Relations Board. She began as a field attorney in 1995, first working in the board's Buffalo, New York office, and then transferring to Cincinnati. In her role, Ms. Clark was responsible for investigating and litigating unfair labor practice cases, presiding as a hearing officer in contested representation election cases, and serving as counsel for the NLRB in federal district court proceedings. She currently supervises a team of field attorneys and field examiners in performing the same activities. She is presented at various continuing legal education seminars on behalf of the regional office and currently does outreach on behalf of the region. She has served as the region's Equal Employment Opportunity Officer from 2000 until 2015, and was also an adjunct professor at the Northern Kentucky University Salmon P. Chase College of Law, where she taught labor law from 2010 to 2014. She received her bachelor's degree from Ohio University in 1990 and her Juris Doctorate from the Ohio State University Michael Moritz College of Law in 1995. Please join me in welcoming Naima Clark to hear her presentation today. Thank you.
Thank you, Chris. After hearing you read that bio, I'm thinking I need to shorten that thing because one, it's too long, and two, it really raises some expectations there that I just didn't realize would be there until I heard you read it. So I don't want to set myself up for failure. Just a little joke there.
I'm sure you will not fail us. It will be an amazing presentation.
Thank you. Thank you very much for that. So thank you all as well for inviting the agency here to address you and talk about the GCs, the new GCs initiatives since being named to the agency. So there is a lot of information, a lot of initiatives that have come out in the 3 memos that I'm going to be talking about today, as well as the letter. So I'm not going to cover everything in great deal. It would just pretty much take all day. I am going to hit on the highlights, and I welcome, your questions that you have. Generally, I'm going to move through and sort of cover some of the topics that are described in today's meeting description. And I'll take your questions. I'm happy to take them as we go along. I'm also happy to take them at the end. So if you feel like there's something super pressing, you can feel free to raise your hand, and we'll just kind of work that way with it. The primary memo that I'm going to be covering today is the mandatory submissions to advice memo. These are all public and available on our website at www.nlrb.gov. And I don't have a PowerPoint. I do have those documents open on my computer. If I can probably find a way to maybe put them in the chat if people want to follow along, but they are on our website. The first one I'm going to cover, the mandatory submission to advice, is General GC 2104, and that one issued back in August. And for those of you who may not practice before the board, often I assume if you're here, you do, or have some practice before the board. In many cases that are processed at the regional level, the bulk are governed by extant law board cases that are in pretty, non-controversial and pretty standard. However, in some cases, our division of advice likes to chime in unique sort of situations. Novel cases are typically submitted up through advice for guidance on whether or not there's been an unfair labor practice based on the facts that come out of the investigation. As well, in many cases, new general counsels will often come into the position with some issues that they want to examine and possibly get before the board for consideration. And so the memo that the GC issued covers all of these areas. One is cases and subject matter areas where in the last several years, the board overruled legal precedent. These are cases involving board doctrinal shifts, and those are the ones I'm going to be touching on today. But the memo will also cover, also contains other initiatives and areas that are ones that the general counsel would just like to carefully examine. And then there are the traditional types of case handling matters that get submitted to advice. One of the biggies in this memo are employer handbook rules. These are rules that everybody lives by on a day-to-day basis in the workplace. And the question is, in what way might those rules affect or impact employee Section 7 rights? And that question is one on which there is tension and back and forth in some board cases. Most recently, there was a case that many of you are probably familiar with, the Boeing Company case, which overruled a prior doctrinal case, St. Lutheran Village, and imposed a new framework for determining the legality of workplace employee handbook rules. And so what the general counsel wants to look at is cases, the applicability of Boeing to cases involving these rules, including confidentiality rules, non-disparagement rules, social media rules, media communication rules, civility rules, respectful and professional manner rules, offensive language rules, and no camera rules. All of which, especially social media, confidentiality, camera, these are biggies that obviously many companies want to have in place. So Boeing overruled existing precedent and created a new test for evaluating employers' work rules. Under the prior case, Lutheran Heritage Village, there was a sort of three-pronged test for looking at these these handbook rules. One was whether employees would reasonably construe the language to prohibit Section 7 activity. Secondly, the board would look at whether the rule was promulgated in response to union activity. And finally, the board would look at whether the rule had been applied to restrict the exercise of Section 7 rights. So Section 7 refers to generally the employee's rights to form, join, or assist a labor organization in the workplace to work together for their own mutual aid or protection. And there's some more language there, but that's the meat of it. And that is really the central piece of the National Labor Relations Act. And what is always being looked at when the board is considering whether conduct interferes with that right. So in Boeing, the board in Lutheran Heritage Village, the board had defined sort of these three categories of rules that I just described. The first one is the one that really creates the big problem, and that's where the cases are being looked at. So that's the one, whether employees would reasonably construe the language to prohibit Section 7 activity. In all the cases where that's been looked at, those have been facially neutral rules that don't directly implicate terms and conditions of employment or Section 7 rights, but rather on their face, just say something like, you can't use cameras in the workplace. That's what was going on in Boeing. The employer prohibited employees from recording in the workplace. They had a no camera policy or taking pictures. So that doesn't say anything about working together for your mutual aid and protection or joining a union or anything else that Section 7 protects. So the question is, what standard do we apply to these rules? In St. Lutheran Village, the standard had been, how would the employee reasonably construe this rule? And under that standard application, a rule prohibiting employees from recording or taking pictures might reasonably construed to prohibit employees from engaging in Section 7 activity because, pardon me, employees might actually be recording or taking pictures to maybe document safety issues in the workplace, for example, and they may work together to try to to change those or improve those conditions. So that is the way in which a facially neutral rule under the reasonable interpretation standard could be construed to interfere with employee Section 7 rights. So the board in Boeing, which is still good law, changed that framework and establish specifically that prong, just the reasonable standard. The law saying, obviously if the rule directly implicates protected activity or Section 7 activity, I'm sort of using that interchangeably, then it's still unlawful. And if it's applied in a way, although facially neutral, if it's applied in a way that interferes with Section 7 rights or in a discriminatory manner, for example, so it may be facially neutral, it may be a facially neutral and lawful, say, no solicitation policy, but if it's only applied in a way to restrict union activity or other protected activity under the Act, then that would make the application of it unlawful. But the rule itself, there are cases holding that the rule itself would not have to be rescinded, just the application of the rule in the unlawful way. So we're just going back to the reasonably construed cases. So under the test that the board set forth in Boeing, if these rules are not explicitly unlawful, instead of looking at it from a reasonable construction standard or reasonably how the employees will reasonably view it, the board does a balancing test now and evaluates whether the rule's has the potential impact on protected concerted activity against the employer's legitimate business justifications for maintaining the rule. So in applying that standard, the board found that the no camera rule was not unlawful, that it was actually lawful. The employer had presented justifications for the rule that outweighed any potential infringement on employees' Section 7 rights, including the protection of information implicating national security, proprietary trade secrets, and employees' personnel information that all outweigh the employees' rights. And then the board set forth this sort of category, a plan to categorize these different rules so that in future cases there would be parties would better be able to predict what might or might not constitute an unlawful rule. So they sort of created these categories, 1, 2, 3 categories to place rules in based on the board's application of the test in future cases. And so they did talk about category 1 cases, rules such as the no camera requirement in this case, rules requiring harmonious interactions and relationships, and rules requiring employees to abide by basic standards of civility. Quite honestly, in Boeing, really underlying Boeing and what was really under attack was cases decided under Lutheran Village, and other cases that involve, let's say, language lacking civility or conduct lacking civility, conduct which, I think to the common person would view it and not question how an employer or why an employer might discharge this person. So what the board sought to do was to preserve the employer's rights to maintain civility in the workplace. But what we know in this field in investigating cases is that oftentimes the workplace is a place where people engage in very robust exchanges that may also include activity that's protected by the Act. And the aim in many of the cases that the Boeing board looked at was to protect that right and not necessarily the lack of civility that was involved in the exchange. So that's Boeing, that's where things currently stand. And the General Counsel is asking, so what happens at the regional levels is we get cases that may raise these issues, and before making a determination on them, we send them up to advice and give them an opportunity to look at it and decide whether or not it might be a case that the General Counsel would want to consider basically getting before the board, to have the board take another look at it. LA Specialty is another case specifically listed in the menu involving, in the memo, and involving these handbook rules. And the rules at issue there were rules that prohibited the disclosure of confidential and proprietary customer and vendor lists. And the board there said that those rules too would fall within category 1 and in general would not be found to be unlawful. Previously, such rules might, when examined on a case-by-case basis and within context, might be found to have been unlawful because employees do have the right to appeal to customers or vendors in support of a labor dispute, for example. They may also, want to contact coworkers. So when you have like employee lists and whether or not those might be considered confidential or protected information, not protected by the Act, but confidential information as defined by the employer, that might interfere if employees are afraid of breaking a company rule by, say, sharing this information amongst each other or even with an outside union that might be trying to organize the employees. There was also in that LA Specialty case a media contact rule that the board also said was not unlawful. And that rule, employees stated that employees approached for interview and or comments by the news media cannot provide them with any information. Our president is the only person authorized and designated to comment on company policies or any event that may affect our organization. Again, doesn't sound, sounds just fine, and the board in LA Specialty thought so as well, not to oversimplify it here. But in that case, again, it was conducting a balancing test. As well, in that case, the board did, look at the reasonable standard, not that they returned to Lutheran Village, but what they said is that employees wouldn't view this because the protected activity there is, hey, if employees want to bring attention to a workplace dispute, whether it be union organizing and they're claiming the company's, engage in unfair labor practices, or if there's no union activity and they just want to bring attention to some group dispute that they brought to the company, they may be approached by the media. They may want to make a statement. They may want to be interviewed. An employee might view this policy as prohibiting them from doing so, and they may believe that they would do it at the risk of being disciplined. The board in LA Specialty didn't think so, and the board in LA Specialty did assume that employees are concerned with the everydayness of their work, And they're not reading policies like this to prohibit such activity. They read it and sort of take it for face value, and they look at it and say, hey, yeah, we understand the company is just saying that we can't speak on behalf of the company, but we can still speak on behalf of ourselves. And so the board said that rules like that would generally be found to be lawful. Moving on to another subject or topic, the General Counsel is also looking at cases involving the applicability of a case called Baylor University Medical Center, which overruled a prior board case and found that separation agreements that contain confidentiality and non-disparagement clauses, as well as those prohibiting the departing employee from participating in claims brought by any third party against the employer in return for severance monies, lawful. So the General Counsel is also looking at confidentiality provisions and separation agreements. And we'll talk also a little bit about those in settlement agreements. Any of you who maybe have practiced before the board or tried to resolve a case out, informally through the parties and not involving the board may have bumped up against our policy of not approving adjusted withdrawals that do contain confidentiality provisions. So this is not exactly that. This has to do with cases that have gone up before the board. And so in the Baylor case, that involved three particular provisions, and these were voluntary severance agreements that were offered to departing employees in exchange for severance pay and other post-employment benefits that to which they wouldn't otherwise not have been entitled. So these cases, this Baylor case, and also there's another case, International Game Technology, that dealt with non-disparagement or making statements that were detrimental to the business or reputation. These all arose within the context of cases where the employees had not been unlawfully discharged. So in those cases where we have settlements and you're before the board and there's either been a finding of merit, at least by the region, or a party thinks there might be a finding of merit and they sort of want to offer something to a charging party to resolve it, that's different because those cases raise the specter of potential unlawful conduct by a party and a person being discharged or terminated. Whereas here, the board was simply saying that the mere offering of these terms or maintenance of these terms infringed on employee Section 7 rights and was unlawful. At least that's what the board had said in prior cases. And in these cases, in Baylor and in International Game Technology, the board said, no, there's no specter of any sort of unlawful conduct. These agreements were purely voluntary. They were offered in exchange, there was consideration supporting them. They were offered in exchange for a benefit, and they didn't implicate any terms and conditions of employment. These employees would be gone off, and no longer working for the company. And so they said that offering them was not unlawful. So look out, that's another issue that the General Counsel wants to see cases on and may seek to possibly put cases before the board that may look at that and possibly seek to change it. I want to note in that case, in Baylor, the ALJ had found that these provisions were unlawful, applying the Boeing test and saying that under Boeing, these constituted rules. And the board said, no, these aren't rules. The GC didn't claim that they were rules. These are provisions contained in proposed releases and separation agreements. They're not rules and you don't apply Boeing. Okay. Moving on to another This still falls under the confidentiality and separate provisions. This has to do with confidentiality in workplace investigations, which I think is kind of another biggie and why I chose it, because workplace investigations, when there are allegations of either misconduct or even allegations of, that might potentially not only violate employee handbooks, but might also violate the law, when I'm thinking sexual harassment and things of that nature. So these are cases that apply to this. So previously, these sorts of prohibitions on, where employers would tell employees, hey, we're doing this, you may not share this interview I'm doing with you. You may not talk to anyone else about this investigation. It's confidential. And if you do, you may be disciplined. Previously, before the board's holding, in this case, Apogee Retail LLC, the board would look at this on a case-by-case basis and would hold the employer's feet to the fire, to establish that confidentiality was indeed necessary. So instead of, this categorical claim that, well, they should be confidential, because we want to, generally, protect the confidentiality of the investigation, and we don't want people going around and talking about what's going on. We want to make sure that, you don't taint other, potential witnesses, or people don't get together and start talking about it. And inevitably, sometimes these justifications would go directly to things that employees might do for their own mutual aid or protection. But in any event, the employer's feet would sort of be held to the fire in the cases, and there was a case-by-case really examination as to whether they truly met the burden of showing that confidentiality was necessary. In Apogee, the board overruled that former approach, and this was that prior case was Banner Estrella Medical Center. And instead, they applied the test for facially neutral workplace rules that they had established in Boeing. And so, they said these rules are facially neutral. They don't, on their face, implicate Section 7 rights. And I think before, under prior law, they may not have been viewed as being facially neutral. So that's where some of the tension is. But the board, in this case, said, no, they are facially neutral, and you apply Boeing, and under Boeing, these sorts of confidentiality rules fall within Category 1 and are generally lawful. So that's something else to look out for and be careful about with the confidentiality of investigations, or maintaining the confidentiality of workplace investigations. Another popular one subject is what constitutes protected concerted activity moving along. And we know there's the easy cases, but in many cases you have an individual, at least this is how they come to us, you have an individual come and claim, hey, I did this, I engaged in group activity, and I was fired, and that's wrong, do something about it. So the cases that the General Counsel, one of the cases that she's looking at in this area, are those involving the applicability of a case called All-State Maintenance, which overruled a case called Worldmark by Wyndham, and narrowly construed what rises to the level of concerted activity and what constitutes mutual aid or protection within the meaning of the act. So the Allstate case was interesting. It involved a skycap who was summoned to help a soccer team that was arriving. I don't know where they were, New York City, big soccer team coming in on a plane. They said, hey, we got a big group coming. I'm sorry, they were going to depart. We got a big group coming. We need you to handle their bags. The one skycap says, nah, when they came here last year, those guys didn't tip. So I don't want to go help them. And there were two other skycaps who seemed to be in agreement, although this charging party did not hear them express their disagreement, but they apparently did, and they walked away too, and none of them would help this cheap soccer team that didn't want to tip them, except after the company that employed them had to go and rely on some other sky caps that worked within the airport and who weren't with them to get started. And I think these guys probably maybe either felt bad or were afraid, oh, shoot, we might get fired for doing this. And they did eventually start helping. But in any event, the board said, nah, this guy was not involved in protected concerted activity at all. And not only that, but it was not protected because it didn't have to do with terms and conditions of employment. That was an interesting finding there. Primarily because in that case, they say what he did was more akin to personal griping, individual conduct. He was worried about the fact that these guys didn't tip, and the fact that two other employees happened to have been standing by, and also their supervisor did not convert it into any sort of group activity or anyone seeking to initiate group action. In reaching that conclusion, the board also overruled this case, Worldmark by Wyndham. And that case involved an employee that a company manager approached about this new rule where they had to tuck their shirt in. And this employee, in response, started questioning why we had to do it, questioning the rule. And as he was discussing this new rule or policy, some other coworkers kind of started to gather around. And the guy ended up getting fired. And in that case, the board found that actually was concerted activity, and it had to do with the nature. So they compared this case to other cases where the board found concert is what's really at issue here, whether it's in concert or group activity or whether it's personal griping. And so the board compared that to cases where it had found concert where issues were raised by employees in employee meetings. So this is where the company calls a meeting and maybe announces a new policy. It's like a staff meeting, or generally a staff meeting. They raise a new policy, and then you got that one person who, always speaks up at every staff meeting and maybe criticizes it or questions it or complains about it. Looking at the overall circumstances, which the board always has done when examining whether or not activity is in concert, because that is the directive in those cases. The board has said that is more along the lines of concert, because the employers bringing employees together as a group to deliver the information, to tell them about the new policy or the new rule, and the employee raises the question within that context. And so, looking at it overall, it is concerted. And they applied that to the Worldmark case. The board distinguished the Worldmark case and overturned it, saying that it's, while it might have a shadow of, or shadings of some concern, it really was unclear enough to stand as precedent, and they overruled it and really went back and said, in order to find concern based on activity that takes place, or individual conduct, I should say, within a staff meeting or a group meeting, there has to be more than just the fact that there was a staff meeting going on. But in either case, this line of cases, as well as the leading case where there was a doctrinal shift, all state maintenance, are being examined and looked at by the General Counsel. Let's see here, time flies when you're having fun. Another doctrine here, I think this is really interesting, is that the General Counsel is looking at is the applicability of what's called the inherently concerted doctrine. And, I know there's some folks that don't like to hear about inherently anything, because when you say inherently, you're saying just the very fact of something. It is for some people here inherently, and understandably say that means that the General Counsel is not going to have to meet a certain burden. It's kind of like something is inherently destructive of employee rights. That means the general counsel doesn't have the burden of establishing animus. So there's certain folks out there who would view it that way. And so you guys will want to pay attention to this inherently concerted doctrine. But there's a very common one that we all, well, most people know about, but you'd be surprised. I think this is probably the least misunderstood rule, and most people think it's okay. Wages, the discussion of wages. There's long held, case law doctrine holding that the very act of discussing wages with a coworker is inherently concerted, so to speak, because it is sort of the foundation for potential concerted activity. Going to ask a coworker, how much do you make? How much was your raise? People commonly think that it's okay for employers to have rules that prohibit these discussions. Many professionals, I think many HR people, many employees, I've seen it be stated on TV shows, not that that is any indicator of accuracy, or that there are always bastions of accuracy, but it's very commonly held. But so that's an inherently concerted doctrinal case that we all sort of know about. But in this case that the general counsel is looking at hood view vending, she is looking at whether there are other types of discussions alone that would be considered inherently concerted. And that means that there is not the typical requirement that you have this evidence that it was either an inducement to group action or that there was actual an outgrowth of group action. Here, it is an individual. So in that case, this employee woman had actually failed to come into work when she was required to after her leave had been denied, to take off for funeral leave to go to her father's, the interment of his ashes. And they said, sorry, we don't have enough people to cover you, so you can't have that day. And she ended up calling off and said, hey, I can't do this, I'm taking it anyway. That was on a Friday. She was ordered, you need to come back in on Monday or you're going to be fired. Over the weekend, she saw a job posting for a job at her company. And when she came to work on Monday, she spoke to a coworker and said, hey, I saw this job posting. And actually, I think the posting just said a company in the whatever town the company was in. It didn't identify the employer by name. And she said to her coworker, did you see that? And he's like, yeah. And she says, that's got to be our company. It sounds like somebody's going to get fired. Do you know anything about it? He says no. And so, but for some reason, the coworker that she spoke to thought that meant that he was going to get fired, and she was somehow suggesting that he was the one who was about to be let go. So he then goes to the company owners. This is sounds like a relatively small company, and says, hey, am I going to be fired? She just told me I might be fired. Well, no, he suggested, she told me about this job posting, and I'm just wondering if I'm going to be fired. Anyway, the long and short of it is that the company ultimately fired the discharging party. And the reasons that they gave were not really about the fact that she had called off that day that she was supposed to come into work. It was that she was telling and making these statements about the job posting that she had seen, and sort of spreading rumors and making employees think that they were going to get fired. In that case, this actually is not a case that was decided more recently. This is a case from 2012 that was decided by a board under the previous Obama administration. And so this is the case that the General Counsel is wanting regional offices to look at and consider what types of conduct might be inherently concerted. So in this case, the board, in Hood View, found that was inherently concerted, that discussing job security meaning whether and under what circumstances employees will be discharged or laid off, and with what procedural protections, concern the very existence of the employment relationship, and accordingly, any concerns about job security quickly ripple through and resonate with the workforce. So there is precedent for finding that more than just discussion of wages is inherently concerted. Let's see, it's 12:41, so I'm gonna skate through this next one, and this one was another big one when it came out. Purple Communications initially, which had overturned Register Guard, and that's which Register Guard said that emails are owned by companies. They don't have to let the employees use them if they don't want to engage in Section 7 activity. It's a property right that outweighs that. Purple Communications Board said, nah, the email is like standing by the water cooler, and employers open it up anyway. And so there are certain conditions under which, prohibition against using email for that purpose will be unlawful. And then in Rio, in 2019, a case called Rio All Suites Hotel and Casino, the board returned to Register Guard and overruled Purple Communications. And so now the current general counsel is wanting to look at those cases and how they might apply to not only email, but to other electronic platforms in the workplace, such as the memo lists Discord, which I never heard of, Slack, that I never heard of. Neither one of those seem like platforms that a company would want to use for communicating with its workers or for employees to use amongst each other. But I guess at least one of them might potentially be used by employers. Slack. I looked it up online and it says Slack is a new way to communicate with your team. It's faster, better organized, and more secure. So there might be companies out there using Slack. There's also an app, GroupMe, which is just used for group text messaging. So and other employer communication systems that might be used. So, look for that to be an issue that is looked at by the general counsel. Let's see here. Another quick one that I'll just touch on, cases involving the applicability of a case called Wynn Las Vegas, which overruled the standard for distinguishing solicitation from mere union talk, which was articulated in a prior case. That, that's one of those little slippery ones. And I mean, without doctrinal shifts, it's always a close call. So that the question there is, there are cases, the leading case being Republic Aviation, that, protects employees' rights to talk about unions in the workplace. And then there's this distinction between, are you just talking about the union, like you talked about whether or not, in my case, the Bengals won or lost this week? People in Columbus is whether Ohio State won or lost, and Cleveland, whether the Browns won or lost. So just talk about whether or not you happen to support the union, or maybe even trying to convince your coworker that the Browns are a good team versus the Bengals or not. All sort of fall within that sort of talk that might occur while you're working. Whereas solicitation is something that may be relegated. In other words, if it's an actual solicitation, an employer can lawfully say, hey, you got to do that on your non-working time. And so what constitutes talk versus solicitation is what's addressed in this case, Wynn Las Vegas. And most recently, the board in that case found that there was no proffering of any sort of authorization card, which in prior cases, the board has said there has to be something more than talk. There's a proffering of a card. That's what the actual solicitation is. And they said, no, it doesn't have to be a card involved. You can have solicitation without the proffering of a card, or without literally saying to your coworker, hey, will you sign a card? Will you go meet me on break and sign a card, or will you support the union? So that case sort of expanded the definition of what constitutes solicitation. Moving on to some of the remedial issues that I said I would cover. In general, the sort of common theme here with remedial issues is that the General Counsel is viewing it from a certainly very robust standpoint. And she lays out in this General Counsel 2106, which is seeking full remedies. And that sort of reinforces and sort of lays out all the sort of remedies beyond. We know that the Act says make whole remedies. You restore employees to the status quo. And whether or not that means that things such as consequential damages might be sought has been subject to different interpretation by different general counsels. The previous general counsel rescinded memos instructing regional offices to seek consequential damages. This memo from the general counsel thinks that consequential damages fall within restoration of the status quo and make whole remedies. And so that includes things that are a consequence of the unlawful discharge, such as, not your whole house, but to the extent that you maybe paid late fees on your mortgage or fell so far behind that there were consequences that you had to expend more money, in response to, might constitute consequential damages. And so things such as front pay, as well as liquidated, that's a procedural thing, liquidating back pay and in a combined complaint with compliance specifications where appropriate as well. That's procedural, not substantive. Where unlawful firings of undocumented workers are implicated, the General Counsel has instructed regions to seek, in addition to traditional remedies highlighted in other memo, compensation for work performed under unlawfully imposed terms, such as work performed under an unlawfully reduced pay rate, and also employer sponsorship of work authorizations, and other remedies that would prevent an employer from being unjustly enriched by its unlawful treatment of undocumented workers who are still employees under the Act, although there have been limitations placed on what types of remedies or whether they would be able to lawfully be ordered to receive back pay, whether employer could lawfully, whether the agency could lawfully order employers to pay back pay to them. So that area is limited, meaning that they're not always entitled to everything that a documented worker would be entitled to under the Act. In cases involving unlawful conduct committed during a union organizing drive, some things that the General Counsel lists, union access, reimbursement of organizational costs, distribution of notices and board orders to both current and new supervisors and managers, along with trainings of employees on employees' rights under the Act. Also, any of you who've, negotiated or discussed settlement agreements with us, we look for, electronic postings. We live in a different day and age. We're well beyond the time of just posting a notice, in the break room or on the company premises. And we look for postings on employers' intranets, or I shouldn't say employers' charged parties, because unions are also charged parties. And probably one case in particular comes to mind where this was a huge issue. Actually, the charged party was a union. So intranets, Facebook pages, social media pages, and usually in cases where those social media pages are public, we haven't so much sought it, but where they're private and sort of members only social media pages, then in those cases, we have sought to have the notice put on the social media pages, and then also sending notices via text message. So those are some of the other sorts of ways in which you will maybe be seeing in some proposed settlement agreements that notices should be posted. Many of you may have also seen by now that we have returned to including default provisions in settlement agreements. as a matter of course, and not previously we had been instructed to do it based on the particular charged party's possible recidivism or prior cases, prior merit cases, but now we're including them as a matter of course. And this is new, no non-admissions clauses. The General Counsel is not viewing those very favorably. So it's not I don't know if it's a blanket no, but it's yes is probably the exception and not the rule. So that's a little bit about settlement agreements. We have 10 minutes or 9 minutes. So if there were questions, I did want to leave time for that. So, the other topic I was going to cover were this other issue that she's looking at is players at academic institutions and scholarship football players being classified as employees.
I'm on my phone.
You can remove your mask if you want.
Oh, yeah. I mean, where are the Zoom controls? Do you see them?
And misclassifying them as student athletes being considered a unfair labor practice. Now, remember, all you Ohio State fans, don't start shaking in your shoes and getting scared, because that's a public university and we don't have jurisdiction over any governmental or state entity. So Ohio State is out, but think of the private universities. In the big case, Northwestern University, which I think came out in like 2016, where you had the Region 8 case where at the age of, I'm saying 16 because my son, I think, was 16 at the time, but he was actually older than that in 2016. He was 18 for the first time in 18 years, actually paid attention to what I did in my job. The first time my job and agency had any relevance, he was like, hey, football players are employees. I mean, college football players. And so that case really brought a lot of attention to the agency. But anyway, we ultimately did not seek the board to make that finding or enforce it. But this General Counsel is very much interested in this issue and believes that student athletes is a misclassification, that scholarship players at these private universities are fit the broad definition of employee within the meaning of the act, or can. It's still they would still have to meet certain criteria, and certain factors would need to be present for them to constitute employees. But that's another issue. And then just a few notes about outreach. I think I mentioned that just the General Counsel has gotten a very robust outreach program going within the agency. So some of you all out there may receive invitations from our office or the Region 8 office in Cleveland. I think everybody here is in Ohio, to conduct outreach on both sides. And also we are really working to try to reach underserved populations and just people who may not normally, because we're such a specialized agency and we're usually talking at events like this where we're sort of talking to people who are practicing in the area or who are part of the labor and employment bar. We're not so much talking to people who don't know about the act or don't know about the rights under the act. And so we have a very robust outreach program that we are implementing. So you may hear more about that. So I did want to let everyone know. And if you go to our website, and our website has a page for each region, and each region's page should list their outreach coordinator so that you can reach out directly to that person if you are interested in having us come and conduct some sort of outreach or anything like that. So we have 5 minutes now, and if there are any questions, I want to open the floor up and take any questions from you all. I can't see if hands are raised. Chris is going to help me there. If I don't have questions, then I can keep running my mouth and say a few more things. any questions, even about the regional office, about what I've spoken about, any things along those lines? Okay. No hands. Okay. That's for those of you planning to request CLE credits. Be sure to take the survey.
Please,
Okay.
I have put the link in the chat message board for those of you who need CLE credits. So, any questions from our participants today?
I think I see Alan Kinzer. I saw his name on here. He's on this committee with me.
I am here. Hi.
Hey,
Hi, Nima. How you doing?
good. I was about to give a plug for anybody who, was so enthralled by my presentation today and you're begging for more, which I can see you are. Our General Counsel, Jennifer Abruzzo, will be at this seminar, the Ohio State Bar Association, in connection with the NLRB Regions 8 and 9. We annually put on an NLRB update, and that is in December of this year. And
December 14.
Thanks, Alan, because I hadn't opened it up yet. But yeah, both the General Counsel, Jennifer Abruzzo, as well as Board Chairman Laura McFerrin will be there, as well as a spokesperson from our Representational Appeals Office who can answer questions about representational issues. I didn't get into a lot here. Most of what I discussed, all of what I discussed really had to do with unfair labor practices, but of course we also conduct representation elections. And before I got on here and having my discussion with Chris and the smaller group, we talked about the Starbucks case. I came out of the Buffalo office, and for the first time, I think there is the potential of unionization, or there is organizing an actual election taking place at Starbucks in Starbucks locations in Buffalo, New York. And I don't think any corporate-owned Starbucks, according to what I've read in the paper, not any internal information, have never been organized. So there's obviously a lot that we do on the representation side, and that's been an interesting case to follow. Starbucks is a huge corporation, very popular.
And I would also plug that Naima mentioned that we'll have the appeals person for the representation cases. Terry will be there, and he will be describing what the rules are, because the NLRB's rules on the procedural rules for representation cases has kind of been in flux with court challenges going on. And so we'll be going over what the rules are, and then some of the nuances and some of these court cases that will be coming down concerning those procedural rules.
Well, thank you so much to both of you for providing us with the additional information about the December event. That's definitely something that I'm glad to have let our individuals know about. And thank you so much, Naima, for your lecture today. That was great information that I'm sure everybody has really appreciated. I know I enjoyed hearing about it. You had some really good information for us today. And I believe, Don, are you still on? Is he still hiding somewhere, or is he logged off? There he is. I think I saw him.
There he is.
That we always like to provide our speakers with a Colera cup. Are we still doing that, Don?
Yes, we are.
Okay.
Yes, we are.
So you will receive a free cup for having been a speaker for us for the day. So I assume we're mailing them. Is that what we're doing, Don?
Yes. Yes.
Okay. You will receive it in the mail as a sign of our gratitude and appreciation for such a great lecture today. Thank you very much for participating. We really appreciate it.
Thank you, Chris. I have a collection of cups, so I'm happy to be able to add this one to it.
Excellent. Excellent. We always like to add to collections because we all know we all have so few of them, right? Thank you very much for participating today, though. We really appreciated it.
Thank you.
Thank you.
Anything?
Everyone have,
Oh, go ahead. Go ahead.
oh, I was gonna wish everyone a good day. I didn't know if y'all had more business after
I was just going to say, Dawn, is there anything that we need to add today before we sign out for the day?
The only thing is our next month's speaker is Craig Zimper from State Employment Relations Board. And he's going to talk to us about SERB activities over the last year and how active they've been or what impacts, some of the, pandemic has had on what they do and whatnot. And I think that should be interesting.
Yes, we are looking forward to hearing from the SERB folks on that. So very much looking forward to that. And if there's nothing else, I think that's all we have for you folks. Thank you so much for attending today.
Very
Hope you
good.
enjoy.
Thank you.